So Robert, we're lawyers, so, we go around and we make arguments and judges and juries listen to what we have to say. But there's always some level that we have to prove something to, right?
Correct.
What is that called?
That's a burden of proof is the level you have to prove, and the law would tell what level of that burden of proof is.
And so burden of proof is really kind of how certain are you something happens, right?
Correct.
And so like the lowest standard is a reasonable suspicion, and that's used by law enforcement generally to like stop and frisk somebody. What is a reasonable suspicion?
So it doesn't mean that you have to know for certain that something's happened, but the smell test would say something's there, so it's okay.
It's pretty low standard.
Low standard, yes.
Right, and so if a cop or a law enforcement agent has a reasonable suspicion that you've committed a crime, they can stop you and detain you, and then even for their personal safety, do a frisk, right?
That's correct.
And that standard is even lower than probable cause, right?
Right.
Now, probable cause is a standard that law enforcement uses to get like warrants for arrest, search warrants, and search affidavits. What is that level of proof or burden of proof?
So that burden of proof is also low. It's higher than reasonable suspicion, but you have to have some evidence to show that you think a crime was committed, or there's a reason to believe that you need some assistance from the court to get additional evidence. But it's not the standard that you would see on the courtroom TV. It's that level.
Right. So it's a clearly articulable standard where a reasonable magistrate would believe that the evidence that the government is looking for is either that of a crime or what they say it is, right?
Right.
And this is what the magistrate or the judge has to find to issue a search authorization or a search warrant or seizure authorization, right?
Correct.
Now, if the court doesn't find probable cause, will they issue the warrant or the search authorization?
They do not find probable cause. They cannot issue those requests made by the government.
So what does CID or law enforcement do if they know they can't get a probable cause authorization past a judge or a magistrate?
So typically they'll go back and try to find additional evidence that would support their position that they can lawfully get.
Yeah. My experience has been that they'll just try to trick the soldier into giving them the evidence by asking them to consent or to voluntarily give it. Should a soldier ever voluntarily give evidence or provide information without seeing a lawyer?
They should never do that. Now, a lot of soldiers will think that they're helping their cause, or they're under some sort of order by their commander to provide that information, but that is not the case. If they are asking about, if they're asking about a crime, then you need to first get your rights read to you, and then you need to seek a lawyer immediately.
Okay. Now, the first standard that we see in the courtroom or that we see applied in the military is by the preponderance of the evidence. What is that?
So if you had a scale, the preponderance of the evidence would be 51%. So it's just one side has more proof than the other. So it's it's still a lower standard. It's higher than probable cause. It's higher than reasonable suspicion, but it's still a lower standard to prove.
Right. I've heard some commentators and judges even refer to it as more likely than not.
Right. That's just right.
And so that standard is used like in a administrative separation board, or now even in an Article 15, that is it more likely than not that the soldier, sailor, airman, Marine, Coast Guardsman, or Guardian engaged in the misconduct? And all they have to find is, there's more evidence that they did than they didn't. And that's by the preponderance of the evidence.
And as it relates to preponderance of evidence, even if the soldier is not affected by some military court, if they're in the civilian sector, because a lot of civilians sector folds into that. If it's a civil court, if it's a contract, if it's a divorce, it's still that same standard. It's still the same standard for that.
There's this level of burden of proof that's higher than the preponderance of the evidence, but lower than the criminal standard of beyond a reasonable doubt. What is that?
That's clear and convincing evidence.
What is clear and convincing evidence?
So clear and convincing evidence is a standard that is hard to describe, but it is clear, since the name clear, it is clear that it's more than just 51%, but it's not something where all doubt is out of the picture. So it kind of rests somewhere in between.
Right, and the courts have defined it different ways, right? And so what I would say clear and convincing evidence is that you're pretty damn sure that something happened, but you don't believe it beyond a reasonable doubt.
That's correct.
Pretty accurate.
That's correct.
So what is beyond a reasonable doubt?
So beyond a reasonable doubt, that doesn't mean that that you had to clear all doubt. It just means that beyond a reasonable doubt means that based on the facts and the evidence in front of you, you are certain, but not 100% certain, you are certain that that person committed the crime.
That's the standard in a criminal court, correct?
That's correct.
Both in the military and in the civilian world.
That is correct.
Right. And like you said, you don't have to disprove all doubt, right? Or you don't have to be beyond all doubt, but it has to be beyond all reasonable doubt, right?
That's correct.
And the Army court has defined that as you must exclude every fair and reasonable hypothesis except that of guilt, right?
Right.
So if you have a reasonable alternative to why something happened, then you didn't prove it beyond a reasonable doubt.
That's correct.
Right. If you have any questions about, the burdens of proof or what applies in your particular action, should somebody contact a military lawyer?
Absolutely. They should contact a military lawyer. Absolutely on those. If there's some question, what burden of proof that's there, and you're being questioned by someone, you should always reach out to a military lawyer.
Right. If you're in a legal action and somebody's talking to you about a burden of proof, you need to get a lawyer involved immediately.
That's correct. That is absolutely correct.
My name is Will Helixon. I am the Warrior Advocate. We're the law office of Will M. Helixon. You defend the nation. We defend you.